What happened on January 14th of 2026?
He actually I was out sick, but my supervisor called me at home. He had an admin hearing, and during that, the other safety officer, Officer Robert Menard, tested him, and as he was testing him, Mr. Menard observed him scooping the water out the urinal and handing it to him for a UA. It was cold and it was clear, and there was no way it was his urine.
I filed the complaint.
Don't talk unless somebody's asking. Don't talk unless someone asks you to talk.
No.
Good morning, sir. Are you Justin Joseph?
Good morning.
And this is 20-35818.
Mr. Joseph.
Mr. Joseph, best you can, raise your right hand, sir. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, go.
Mr. Joseph, you state your full name for the record.
Justin Joseph.
Okay, and Mr. Joseph, you do understand we're here to address your bond issues in regards to these cases?
Yes, sir.
Okay. Now, as far as your working situation, do you currently have a job?
I was going back and forth to the Port of Bowman, but before all this had happened, I had filled out an application for AMCO.
Speak up, please.
I said I was working back and forth at the Port of Bowman, but before all this had happened, I had just filled out an application for AMCO off of West Calder doing vacuuming and hydroblasting. Now I'm supposed to start that, but turn myself in to take care of all this.
And as far as any additional responsibilities, especially in regards to your family, what kind of responsibilities are those?
Kids, and I take care of my uncle that just recently fell from out of the ceiling or out of the attic or whatever. He broke his hip bone, so I'll be having to help him, take care of him, take him in and out the bathtub. You have to take him to the restroom because he can't walk and he don't have a walk or anything like that.
So you basically his primary caregiver when you're not working?
Yes, sir.
Okay. Now, as far as expenses, do you have any property or any money saved to put up that you could put toward the bond?
Yes.
Okay. Approximately how much of a bond would you be able to make?
Probably like 10,000 a piece, or no more than 20,000 a piece, probably.
Okay. And as far as any conditions of a bond, a lot of these allegations, of course, deal with drug use. Do you have any concerns or objections to wearing a drug patch or applying with any pretrial conditions judge would have for you?
Well, sir, I can wear a drug patch, ankle monitor, or whatever you need me to do.
I have Ms. Cole here, Your Honor. I'd like to ask her briefly a couple
Yes, of
questions.
course. Good morning, ma'am. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Go ahead.
What can you tell the court what happens when he fails to submit? He's in the office, he's told he needs to do a urinalysis. What happens?
The last time that he failed to submit, he said that his sister had emergency surgery and we were in the UA lab. And I said, if you walk out that door, this is a failure to submit. And we went back and forth for about 5 minutes, and eventually he got up, walked out, and left.
Took longer arguing about it than it would have just to do it.
Absolutely.
What happened on January 14th of 2026?
He actually I was out sick, but my supervisor called me at home. He had an admin hearing, and during that, the other safety officer, Officer Robert Menard, tested him, and as he was testing him, Mr. Menard observed him scooping the water out the urinal and handing it to him for a UA. It was cold and it was clear, and there was no way it was his urine.
I filed the complaint.
Don't talk unless somebody's asking you. Don't talk unless someone asks you to talk. Okay. And so, Mr. Nichols, what's the state's position?
Judge, he's got 3 prior felony convictions. He's on straight probation on these 2 cases. At the time he was placed on probation, a felon in possession of a firearm case and a possession of phencyclidine PCP case were also dismissed. He was put on high-medium caseload. He's failed to follow through with what he's been ordered to do with SafeP. He had he was ordered a little over a year ago to do the Safe Peak program and has chosen not to comply with the requirements of it afterwards, and he's tried to falsify the testing. Judge, while he may be entitled to a bond, I would ask that the court make it sufficiently high to keep him here in Jefferson.
No, they're both adjudicated, so
Oh,
it's not
then
necessary.
I'm asking for no bond, Judge, because frankly, I don't think that he's done anything to show the court that he's going to follow the court's rules while out on bond.
All right, Mr. Lewis, argument.
Judge, understandably, yes, he is not entitled to a bond. We are asking for one, given the issue of him trying to maintain employment and also caring for his uncle while we're out getting just trying to resolve this issue. I believe any concerns of the court can be cured by the drug patch or some sort of pretrial condition that can monitor any drug use or anything while he is out on bond. I believe a bond of $15,000 for each case will be sufficient of that. He's definitely, once the violation came up and everything, I can only speak to, my involvement as far as him trying to do what he needs to do to get things, taken care of. Some of these allegations are my first time hearing about them, but and I'll address them with Mr. Joseph. But as far as his bond, I do believe a bond of $15,000 will be sufficient to maintain his return to court, and also a bond condition of a drug patch or a scram device or something of that matter could definitely keep the court in the loop, if you will, as far as if he does relapse or is any other drug use.
Well, here's the problem, Mr. Joseph. There's nothing more strict, really, than going through that safety program and the aftercare. And that's, like Mr. Lewis said, for me to keep an eye on you is for probation and those programs to keep an eye on you. And what I'm seeing and what gives me concern is that back last year, I'm looking at the administrative hearing that led to you going to SafeP. And at that point, you had tested positive for PCP numerous times, and you had also failed to submit numerous times to testing. And then you went to SafeP, and then it just looks like it's the same problem that we don't know. But I would tend to think it would be a fairly good assumption that you were using PCP again, and that's why you didn't want to submit on the numerous dates that you have here. It makes no sense for me to say, okay, well, we sent you to SafeP because you had a problem with PCP. You got out, and then you did aftercare, and you couldn't get through it because you were trying to either falsify or not show up. So it doesn't make any sense to me that it would be safe to put you back out in the community at this point, because you're not going to just remain on probation, either not at all or without some further inpatient treatment, which we've already done. So I'm not sure where we'll get on the motions, but as far as the bonds go, I'm going to deny those motions in each case for a bond and leave these both at a no bond, because I feel like that is in the best interest of our community, to keep everything safe and to keep you from using something as serious as PCP. All right.
I don't use these ways.
What?
Say I don't use.
Well, then why didn't you take the test?
The only time I gave it to my attorney, Mr. Lewis, when I had, I'm on colors over there. So whenever my color head came up, I was at the emergency room. I gave him my doctor's excuse, and I also brought it to Ms. Cole, and that was cool.
There's 1, 2, 3, 4, 5. Five allegations that you didn't submit. That you didn't submit, and then there's the one where you did, and the allegation is that you attempted to get it out of the toilet.
Yeah, that's what I had to play on. Because when you,
I'm denying the bond. You can go back with the bailiff. Sorry, it's taking. You are charged with evading arrest or detention with previous conviction, and that's on August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third-degree felony, March 28th of 2013. And after that was final, you were convicted of assault, a third-degree felony, September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is from August 31st of 2025. That indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file, a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or the rest of your life. Do you understand? And then finally, in cause number 25 DCCR 1778.
Once we get all these done.
You're charged with a third-degree felony offense of deadly conduct discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases, I have here on this tablet a plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases, a 15-year term, and then in.
It's 15 on all, concurrent on all of them, Judge.
Do you understand what the state has offered you?
Hmm.
And so you have every right to reject that offer and have all 3 of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that?
Yeah.
And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. Oville, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court, or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. Oville, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. Oville, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
Thank you.
Thank you. Good morning. Are you Howard Walker Jr.? And Mr. Walker, in cause number 26, DCCR 0082, you're charged with a first-degree felony offense of injury to a child from December 16th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the minimum punishment is 5 years, up to 99 years or life in prison. Do you understand? And I have here on the tablet a document called the plea bargain rejection that has your signature on it with Mr. Parker's. This shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty in your case for a 30-year term in prison. You have every right to reject that, have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to enter a plea of guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Nicholas, is there any reason to believe that, are you waiting on any evidence?
Judge, there's That offer is based on
I need to get some follow-up medical records to see if that condition has improved or if it's going to be a permanente injury situation. That offer may get worse depending on what we find. Okay, so I do want to make sure you understand, Mr. Walker, that after today, we will not accept this plea agreement unless there's some new evidence that comes to light from your attorney or the state's attorney. Do you understand? Yes, ma'am. All right. And so, also, Mr. Parker's been appointed to represent you, and he's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? Yes, ma'am. All right, Mr. Parker, you're released. Mr. Walker, we will appoint someone today, and they should be out to see you very soon to begin preparation for trial. All right, you can go back with the bailiff.